pleasure to introduce the following speaker, who is closely affiliated with IHS. Donna Matias is the director of the Entrepreneurship Clinic at the University of San Diego Law School. She started this entrepreneur school in the fall of 2001. And prior to that, she was in the lawyer skills instructor program at the same law school. She is a graduate of the University of Chicago Law School and began her law career at Morrison Foerster in San Francisco before moving to Berg, Ziegler, Anderson, and Parker. Is that San Francisco? She left private practice and went to work in the public interest law firm of the Institute for Justice. Okay. For any of you who are new to the liberty movement, IJ is the gold standard. All right? You work for IJ, you're the best. And she was a lawyer for IJ, where she litigated constitutional cases against federal, state, and local entities nationwide. She appeared on television with lots of op-eds about issues relating to her cases. And she also helped establish the IJ Clinic on entrepreneurship at the University of Chicago Law School in 1998. I would also like to add that she is married to Tom Bell, who is speaking later in this seminar. And she met for the first time at an IHS seminar. So, take it away.
Yes, thank you, John. It's actually really a pleasure to be part of this conference today and of IHS. As John has noted, that was it was a big change in my life to go to an IHS seminar, not only because of the exposure to the ideas that I got and to recognize that there were more people out there that felt the way that I did, and I never knew it in college, but because I met my husband of how many years now? 19 years. We've been together 24, and we've got a couple of kids that we brought with us today. So our joke has been that IHS is actually a libertarian eugenics. They're good kids if you get the chance. Anyway, I'm really happy to be here today. As John mentioned, I'm the director of a clinic on entrepreneurship, which is a law school clinic that provides free legal services to low and moderate income entry-level entrepreneurs. And what we basically help them do, we don't litigate for them, but we help them navigate the regulatory maze that's out there. And I'll talk a little bit more about what kind of what an entry-level entrepreneur is up against when they want to try and start their own business. And so I really, though, got the passion for entrepreneurs and entrepreneurship when I was working at IJ, because IJ, as John mentioned, is really the premier litigation shop for libertarian ideas, and especially for challenges to barriers to economic liberty. And I'm here to talk today about economic liberty. For those of you who don't know what it is and what it's about and why it's so important, I hope that you'll come away from this presentation having a better understanding of it and passion for it as much as I do. What do we mean when we talk about economic liberty? You guys probably heard that term. It's not a term you're going to hear from the left very often. But what do you think it means when I say the term economic liberty? Do you have any idea?
He said sound money. Sound money.
Sound money?
Freedom to choose.
Freedom to choose what you do with your money?
Ending cronyism.
Ending cronyism.
Right to earn a living.
Protecting property rights, right to earn a living.
I would say that it means that you own what you produce, and that therefore you should be able to do with it what you want.
You own what you ever hear that? Yes.
Not requiring a license to braid hair.
That's a specific example. Yes.
Voluntary exchange.
Voluntary exchange. It's actually one of those great inalienable rights that encompasses a lot of concepts that we think of when we think of liberty. One is liberty of contract, right? Some of you have mentioned the right to voluntary exchange. It means the right to be able to, if I want to contract with somebody to provide goods or services, I should be able to do that so long as I'm not harming anyone and there's no public, health or safety issue involved. But it's also the right to contract with employers if you're an employee or to hire people, right? So there's a liberty of contract element to it. There's also a property element to it. Somebody else touched on that. Right? I own my labor, and I should be able to dispose of it as I see fit. I own the fruits of my labor, and I should be able to dispose of them as I see fit. And then there's also an element of the pursuit of happiness, right? When we pursue our calling, we want to pursue something that we are skilled at, that we have a passion for, that we're good at. And so long as, again, it's not harming others, we should be able to do that. That's really what economic liberty is about. And again, you're not going to hear that concept really from the left. And I'll talk in a little bit about why that is. But it's important to understand that when someone is allowed to follow their calling and follow their pursuit, it's not just that that person benefits because they're exercising their right. Everybody is better off. Producers, consumers, employers, employees, citizens of a community, right, where you want to have economic growth. Everybody is better off by this. And I think that there's no better example. One of the quintessential examples of that, and Michael, you sort of alluded to it, was a client that I had when I was at the Institute for Justice. She was probably my first economic liberty client. And it was in a case in San Diego, challenging barriers to entering the hair braiding market, natural hair care market. Okay, and the client, there was a woman named Joanne Cornwell. She's actually a professor at San Diego State, professor of African Studies and French. But she has always had this passion and this fascination with hair, and in particular, the natural hair care movement for African American women. And the reason is, and I don't know if any of you know this, but I mean, obviously the hair of people descended from Africa is a very highly textured, coarse hair, and you can't just brush it the way you would brush straight hair, okay? And if you let it go in its natural state, you pretty much, there's the afro is one style. There aren't a lot of styles you can do with it. And so Joanne was always very interested in how to deal with this, because she wanted to go out in the world and look professional, but it was a really difficult thing for someone, especially in the 70s and 80s, when if a woman wore an afro into the workplace in the 80s, or attempted to get hired into the workplace in the 80s wearing an afro, it was very, very difficult to do. It was not acceptable. So she was very interested in the other options available, and there was hair braiding, but she wanted to come up with something else. She's a very creative woman, and so she, after years of sort of experimenting with her own hair and experimenting on her friends, she discovered a way that, based on the way that the hair grows, and as it grows out, the way it behaves, of having the hair lock upon itself. And she came up with tools to ease that along, and she came up with different products to sort of help the hair stay. And she essentially built a business doing this. Okay, there was a big demand. People saw what the style she was wearing. They'd never seen it before. They started asking, "You do that to my hair, right?" And so she'd have people come into her home, and it was a good 5-hour sit-down session, but she started doing people's hair. And she called the style Sisterlocks, by the way. And she started doing Sisterlocks, and then as she traveled for conferences and for various other work events, people around the country would see it. They'd say, "Where did you get that? I love that style. How do I do it?" She realized then that she was really onto something, okay? And she made training videos. She started holding week-long or weekend workshops, training people how to do this method. She wrote textbooks. She did everything. And she did a very smart thing, too, when she came up with this idea. Before she would train anyone in her method, in her technique, she had them sign a confidentiality agreement that said, "I will not show these videos to anyone else. I won't teach this method to anyone else. I will keep this a secret." She realized that there was value in keeping this a secret, right? And she was right about that. And what ended up happening was she created, each time she would teach somebody how to do this, they became a Sisterlocks consultant. They would take that to their city in Atlanta or Chicago or LA or wherever they were, and they were able to establish their own businesses as Sisterlocks consultants. Okay, and there became a great demand for it. It actually, she was in Essence magazine and Black Style magazine and Ebony, and she was very, very successful. Okay, it was all against the law. It was all against the law. That business in California was against the law. And not just because she herself didn't have a cosmetology license. That alone was bad enough. But she was teaching others, and she didn't have a teaching license. And she was performing services in her home, and she didn't have an establishment license, right? So she was putting everything online. She knew she was operating underground, but she also saw what the demand was. She also believed she had a right to do what she was doing. She wasn't using chemicals. She wasn't using fire. She wasn't using anything dangerous. She was basically doing a hairstyle and taking money for it and teaching other people how to do it. So you might ask, well, why would she risk all this? Why wouldn't she just go and get the licenses? Here's why. It would take, at that time, under California law, 1,600 hours of cosmetology classes, so about 9 months out of her life, $7,000, and nothing in the curriculum. Not only did it not teach her method, because she was the one who came up with it, it didn't even teach anything about natural hair care for African American women, right? Nothing. To make it worse, there were a few hours devoted to styling African hair, highly textured hair, as they called it, and they were strictly about using chemical processes and heat on the hair. So it was anathema to what she was trying to do even as a political matter. She absolutely refused to do this. So, and on top of that, she didn't have, like I said, the establishment license and the teacher's license. So, what harm was she doing? Why did she need a license for that, right? That's a classic entry-level entrepreneur position that she started out in, and the jobs that she was creating were classic entry-level entrepreneurs. And in many states where some of her students had been, they were also operating outside the law. She could have gone along like that, right? But she could never develop her business and make it into what she wanted to be. She wasn't able to open a salon to do this, even though she obviously had the clientele for it and the product for it and everything else. She and none of her Sisterlocks consultants, and I think there were about 100 of them at the time, were able to do that because they were operating outside the law. Okay? How did we get to that place where something that seems like it should be an inalienable right is against the law? How did we get to that place? To talk about that, I hope not to bore you with this part, but it is important to understand sort of, there were two main developments in the jurisprudence that really put us on the path that we're on today, and that we were on when we took on the Cornwall case. And so I hope if any of you are not familiar with the law, if your eyes don't glaze over too much. With talk of the law, I'm going to try and keep it really basic because it was kind of complicated, but I think it really is important to understand sort of what was going on in the Supreme Court and with the case law that led us to where we are today. And the first thing is there was a case in 1873, which was about 5 years after the 14th Amendment was ratified, which became part of the Constitution. And it was called Slaughterhouse Cases. And in the Slaughterhouse Cases, the state of Louisiana enacted a statute that said any slaughtering of live animals, not of people, any slaughtering of cattle and whatnot had to be done in one particular site, and it happened to belong to a politically connected company called the Crescent City Company, okay? And what that did was, for all the private butchers that had been operating up until that point, it basically drove them out of business, right? Because they either had to pay a fee to slaughter, and the fees were exorbitant, which was how the Crescent City Company was able to profit from this statute, or they were driven out of business. So a group of private butchers got together, and they brought suit challenging, in federal court, they brought suit challenging this law, and they based their claim on a provision of the 14th Amendment called the Privileges or Immunities Clause. And the Privileges or Immunities Clause was part of the Reconstruction Amendments, and was specifically intended to protect economic liberty, especially for new citizens, meaning newly freed slaves, right? It was specifically intended with the idea that they should be able to pursue their livelihoods. And so that's what the framers of the 14th Amendment had in mind when they wrote the Privileges or Immunities Clause into the 14th Amendment. Now, the 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. So that section of the 14th Amendment contains three provisions that if you are ever listening or interested in constitutional law, you'll hear, but it's the Equal Protection Clause, the Due Process Clause, and the Privileges or Immunities Clause. You won't really hear much about the Privileges or Immunities Clause because, in case I'm talking about, the court pretty much wrote it out of the Constitution. And that's one of the problems that we have today. But in any event, so the butchers brought suit under the Privileges or Immunities Clause, arguing that their livelihoods were protected under this provision, right? And the Supreme Court, in a narrow decision, 5-4 decision, held otherwise. And it's really hard to wrap your head around their reasoning because what they said was, yes, the Privileges or Immunities Clause is meant to protect citizens' rights, but only their rights as federal citizens, not as state citizens. And by comparison, that's a really difficult concept to wrap your head around, and mine too, because we don't think of our rights, our inalienable rights, as these are the ones that states are supposed to protect, and these are the ones that the federal government is supposed to protect, right? That's not the way we conceive of rights. And it would be as if there was a statute passed by Congress that prohibited you from making free speech, okay? And there was the same statute passed by a state legislature that did that. Now, really, if you brought either of those challenges before a federal court, they would not say that if you were talking about the challenge of the state court, oh no, we don't protect those rights if it's the state that's infringing on the First Amendment rights. That's just not the way we conceive of rights. So the Slaughterhouse Cases, that was the decision that they made. And as I said, that basically had the effect of writing that Privileges or Immunities Clause out of the Constitution, because what the court was saying was, if states are passing laws that infringe on your privileges or immunities, we're not touching it. It's not for us to address, okay? Now, it's important to understand, though, that the court did not say there is no such thing as the right to earn an honest living or right to pursue a livelihood. It's just that the Privileges or Immunities Clause doesn't protect it, okay? What that meant was that any time after the Slaughterhouse Cases that someone wanted to bring a challenge under this claim that their livelihood, right to pursue livelihood had been threatened, they had, if they were successful, it would have had to have been under either the Equal Protection Clause or the Due Process Clause. Now, a word about that. Due process, as it was originally intended, was meant that you have a procedure. If you're going to violate somebody's rights or infringe on rights, there's a procedure that you must follow so that we can ensure that the process is fair, but that this is, in the greater scheme of things, this was okay. That's what due process was supposed to mean. What it ended up meaning, there was a line of due process that came about called substantive due process. And that was really all challengers of economic liberty cases or claims had to go on if they were going to go on before use the 14th Amendment, right? Because the Privileges and Immunities or Immunities Clause was no longer there. What it ended up doing, the court still recognized, as I said, that there was a right to earn a livelihood or to earn an honest living. And when those claims were brought, it would look to the substance of the statute that was involved. In other words, it wouldn't just say, okay, state legislature, you passed this, it must be good, and sorry to those of you who have your rights violated. The court didn't do that. They actually did they had a suspicious eye toward any legislation that looked to be protectionist or had some other nefarious purpose other than what it claimed to be, which it always claimed to be in the public good, right, in protection of public health and safety or whatever. So there was an era after Slaughterhouse where you do see the court still protecting the right to earn a living. Okay. So all was pretty well and good, despite the fact that there was no Privileges or Immunities Clause, until the New Deal happened, okay? This is where I have to take it. Okay, so the New Deal happened, and we see our second major development in jurisprudence, and really the one that sounded the death knell, I think, for economic liberty. As you know, during the New Deal, there was a major increase in all types of economic regulation, like price fixing and wage and hour restrictions on businesses, bans on certain products if they happen to compete with other products that had sort of more successful lobbies, dairy, right? So what ended up happening was the court did a major shift during this period. And in particular, there was a case called U.S. versus Caroline Products, and it involved a company that had manufactured a product that was a combination of, I think, skim milk and coconut oil. Which actually sounds kind of good. But it was in violation of a piece of legislation passed with the help of the dairy lobby, or at that time just the big dairy companies. It was called the Filled Milk Act, and it said basically, unless you're selling milk, real milk, everything else is tainted and it's poison, and so you're in violation of this federal statute. And it was very clear from the evidence that this was a statute that was intended to benefit the milk lobby. And so, whereas in the post-Slaughterhouse era, the court would have turned like sort of a suspicious eye if there was any sort of evidence that maybe this was a piece of protectionist legislation. In the Caroline Products case, the court did a huge turnaround and said, we're going to defer to the legislature, and if they say that this is a legitimate public health and safety concern, we gotta believe them. I mean, what evidence do you have, Mr. Producer of Milnut, that it's not? Right, so this was a major shift in the burden of proof that someone making an economic liberty claim had to come forth with. And I'll say a little bit about burdens and burden shifting in trial and in litigation generally. You don't want to be the one that has the burden of proof, okay? And that's particularly true in cases where you're going up against the government. If you have the burden, that means that there's a presumption against you, and you're climbing uphill the whole way to fight it, okay? That's, I think, important to know for this reason. In this Caroline Products case, the court did something else really extraordinary, which was it created a hierarchy of rights. It said, and we don't conceive of our inalienable rights this way, or our fundamental rights this way, but it said, those rights that are enumerated in the Constitution, we're going to give them a lot of protection. In other words, the burden is on the government to prove why it can infringe. But all those other rights, and in particular economic rights, because they're not specifically mentioned in the Bill of Rights or in the Constitution, we're going to defer to the legislature and assume that they know better, right, than anybody whose rights have been infringed. The legislature knows better than we do. And so we really, government wins. Government's going to win, right? And the line of cases that came after that was extraordinary. You see these 8-0 decisions in which the court says to a challenge that somebody's livelihood had been infringed on, the right to earn a living had been infringed on. It might have been that maybe the legislature could have come up with the argument that it's possible that this would be a health and safety reason. Okay, we buy that. And that's really what happened with the evolution of jurisprudence after that. It was extraordinary. And so that, like I say, really was the case in the era that sounded the death knell for people trying to make claims that their economic liberty rights had been violated, or their economic liberty had been violated. And so up until about the 1990s, which was when IJ came on board and was founded with the specific purpose of putting teeth back into the rational basis standard. And rational basis, I mentioned earlier that the fundamental rights, in the Caroline Products case, the fundamental rights were going to get sort of strict scrutiny, and the economic rights got a lesser tier of review. That lesser tier of review is called rational basis review. And that's the review that means basically presumption in favor of the legislature unless there's something really out there that you can prove, some reason why we shouldn't go ahead and put a rubber stamp on what the legislature says. And so so after this case, like I said, up until the mid-90s or the 1990s, when IJ came on board, and they decided that they were going to challenge this way of thinking, because otherwise economic liberty was lost. There's no hope for the entrepreneurs, and especially entry-level entrepreneurs. So again, you have these two developments in jurisprudence that put us on the path that we're on today. And IJ has made some headway, and so as to a lesser extent, by the way, Pacific Legal Foundation. I don't know if you're familiar with their work, but they, to a lesser extent, but not to a less important extent. I need to say that. They're just a smaller operation, and IJ's mission has long been to change the course of jurisprudence and economic liberty realm, as well as others. So one of the major areas that both PLF and IJ operate in is the occupational licensing arena. And I don't know if any of you are familiar with how occupational licensing works, but in every state there's a big occupational licensing scheme. And it started really in the post-Slaughterhouse era. You started to see occupational licensing evolve. And at that time it was in areas that sort of made sense. Doctors, medicine, pharmacy, dentistry, and then it kind of expanded into midwifery and horseshoeing and blacksmithing. And now, athletic trainers, interior designers, florists, shampooers, makeup artists, my favorite, entertainment system installers, okay? So the schemes are out there. Not only are they out there trying to professionalize and keep out entrants into the market, but they do so by coming up with very arbitrary and pretty ridiculous and burdensome requirements. Guess what occupation is probably across the board the most difficult to enter?
Haberdashery.
Oh, that's good. It's close.
Medicine.
Well, aside from the professions. Yes.
Moving truck.
No. Transportation's tough, though. What? Cab driving's tough. I mean, all the transportation are very, very difficult. Babysitting, no. Child care's up there, though. Yeah.
Hairdresser. Hairdresser.
Hairdresser, no. No. No.
Food services.
Florist.
No, not florist anymore.
Oh my God.
It's interior design. 6 years. 6 years for to become an interior designer, to be able to call yourself an interior designer. I can't remember how many states. It's a handful of states that do it. But interior design. Because you don't want to put that couch in the wrong place. It's very dangerous, right? And so the occupational license, that is one of the premier ways to keep out entrance into the market, like new entrants in entry-level occupations, and it's laughable. It really is laughable because even the interior designers claim that they need to do this. They need to have a scheme. They need to have these requirements of schooling and exams and spending this much time apprenticing for the public good, for public health and safety reasons. Okay. It's one of the major things, one of the major barriers right now to entrepreneurship. And the other is just a burdensome regulatory scheme. Anybody that wants to start a business, standard business, and we see this all the time in my clinic, still has to contend with employment laws, insurance laws, tax laws, just local zoning, business regulations, signage laws, all of that. Okay, for somebody, just one person who wants to start something. And they're very, very reluctant to hire people. Why? Because once you hire somebody and pay, I think it's over $100 a quarter, you are on the hook now for a whole host of employment laws. Okay, so it's a very, very difficult thing for entry-level entrepreneurs. And I'll tell you about one of my clients, because I think it really demonstrates how terribly sad it is for the state of our rights, economic liberty rights. We had a client who all she wanted to do was make pillows to put in people, for high-end cars. She was very specific about that. She wouldn't let me put a pillow in my Toyota, but she wanted pillows for high-end cars, and they were going to be, fancy, hand-embroidered, and in the back seats. And I'm not really sure why you need pillows in cars, but that was her thing. So she had tested it out. Some of her friends wanted them, And so she wanted to put these pillows in high-end cars and she wanted to sell them. So it turned out that in order to put pillows in high-end cars, she had to, there are upholstery laws, because upholsterer, by the way, is one of the licensed professions. And there were very extensive labeling laws that defined the size, based on the size of the pillow, what sort of label went on, based on the material of the pillow, the additional label that went on. And it was a ridiculous amount of resources that she would have had to spend labeling just in California. Here's the kicker. Because she wanted to put them in cars, and cars travel across borders, she would have to check on the label laws in every single state, right? Not Hawaii, because you're not going to drive that over the water, but so Hawaii and Alaska she was safe. So 48 states she had to check their labeling laws. And the other thing about that case was that we talked to somebody from the Department of Transportation who said because these pillows are going to go in cars, they also need the materials that she uses have to meet the upholstery requirements, the federal upholstery requirements for flammability. And I mean, all those requirements had to do with when you put seats in your car, you have to have a certain material that meets flammability standard. But her little pillows also had to meet that standard, okay? So guess what? She never started the business. She never hired anybody. She never bought materials that would go into the making of her pillows. She never did any of that because these were such a burden to start this business and to have this business grow. It just didn't happen. Why should you all care about any of this? Some of you are going to want to start businesses. Maybe some of you already have started businesses. And I think it's really important to understand that it's not what you think it should be. You can't just go out and set up shop and think that you're going to be free of regulations and requirements and probably occupational licensing standards if you want to be florists. But the other reason is that even if you're not someone who wants to start a business, I presume you're someone who wants to get a job after college. And small businesses are the predominant source of jobs. They're for college graduates, for young people, for less experienced workers. They tend to, those are the ones that small businesses hire, right? And if they're not out there, you're not getting hired, okay? So I think it's really, really important that we continue the fight for economic liberty, that you are all involved in some way in the liberty movement. I'm so happy to see this many people here. I think it's really important because this is the future. It depends on it, okay? Your livelihoods. And I'm going to close with a quote from Justice William Douglas's dissent in an old case called Varsky versus Board of Regents, which was a case having to do with an attorney that was required to swear an oath to prove he wasn't communist. But Justice Douglas dissented in this case, and he says about the right to work. The right to work was the most precious liberty that man possesses. Man has indeed as much right to work as he has to live, to be free, to own property. It does many men little good to stay alive and free in property if they cannot work. To work means to eat, and it also means to live. So the question here is not what the government must give, but rather what it may not take away.